702.
World of Work.
Today we are discussing retrenchments on our World of Work feature and what your rights are when it comes to retrenchments, because they are often framed as the last resort by employers who are facing financial strain, but they've become a harsh reality in industries ranging from mining to retail. In fact, in recent months, just look at what's been happening in the country. We've seen a wave of retrenchments across various sectors, and that's left many workers anxious about job security and uncertain about their rights. You've got some people that are retrenched without the right process being followed. So what exactly does the law say about retrenchments, and what rights do you as an employee have when facing the possibility of losing your job? I want you to weigh in on this conversation. If you've been retrenched before, I'd like you to share your experience with us. How did you navigate retrenchments? What process did your company follow? If you are an employer, what process do you follow when you have to do retrenchments? How difficult, I can only imagine how difficult it is to call a meeting and tell people that have been taking care of their families through what they earned from your company, and you're telling them this is it. We're not going to be able to continue, or we have to let go of some of you. Please share your experiences with us around retrenchments on 011-883-0702. The WhatsApp line is 072-702-1702. Galeboe Modisapodi is a labor law analyst who's going to guide us through this conversation. Galeboe, thank you for making time. Good morning.
Good morning, Clement, and good morning to the listeners as well.
How does South African law define retrenchment, and how is it different from your normal dismissal?
Retrenchment is different from normal dismissal because a normal dismissal, ordinarily you have done something wrong. In other words, there's some kind of fault on your part that you are dismissed. Maybe you breached company procedures or the rules, or you misbehaved, or you were absent from work, but responsibility can be apportioned to you for the resulting dismissal. In a retrenchment, it's normally understood as a no-fault dismissal or no-fault termination, because it is not your fault that the employer cannot sustain jobs anymore. And on that basis, there are very specific obligations that are imposed on the employer in terms of how to deal with it. So in essence, the difference between a normal dismissal and a retrenchment is that in a normal dismissal, it is your fault, but in a retrenchment, it is not your fault that your job is to an end.
What key steps then must employers follow to ensure that that retrenchment process is fair and is per the law?
The first step is that the employer cannot wait until retrenchment is completely unavoidable. So there's a principle that says the moment the employer contemplates the possibility of a retrenchment, then they should start the consultation process. And part of that in the consultation process is to engage with employees through their representatives, whether they are organized by the union or they decide to elect representatives themselves, but they have to be consulted, amongst other things, on what alternatives are there that can be explored to avoid retrenchment. And some of those have been known to include things like short time. Instead of coming to work every day, maybe you work 2 weeks a month or 1 week a month whilst you retain employment, and hopefully when the economy improves, then you'll be restored to normal work. So that's one of the ways to avoid retrenchment.
Okay, so this must be the last resort, but the company could come up with ways to still keep you, but maybe you're not getting your normal salary given the financial circumstances, but they must explore other options before they decide to completely let you go.
Indeed. And one of the key questions they need to consult on is, what are the reasons for the potential retrenchment? Because they could vary. They could be because the business is in complete financial strain. They could be because the company is restructuring to reposition itself for the future. They could be because the company is introducing new technology, which might mean then that your specific set of skills might not be relevant for the future. So there could be a variety of reasons why there would be a need for retrenchment. And that's one of the reasons why the consultation must take place, because those reasons have to be explored, including the alternatives or means to avoid the retrenchment, if not avoid them completely, at least reduce their impact.
Yeah. And there are often employees who will say, yeah, I just got a letter informing me of my retrenchments and there's not even been any consultation. I know you said that there's got to be a conversation of sorts, but to what extent or even what form must that consultation process take? So do I get informed 2 weeks before I am fully retrenched, I'm let go? Do I get retrenched, a year before, the minute the company realizes that it may be in trouble? How does it work?
As I said, the obligation on the employer is to consult the moment they contemplate the possibility. So if the employer gives you a letter 2 weeks before the closure of the business, it would not have been a proper consultation. It would not have been a fair consultation because there is no time to consider alternatives, to consider counter proposals, or to even present counter proposals in that regard. So the normal period will be roughly about a month or more prior, depending on the size of the employer. So an employer with more than 50 employees is expected, has a lot more obligations compared to an employer with 30, 35 employees. But both of them have to consult, and the new amendment to the Code of Good Practice specifies, I think, in Annexure A, how the notice must be given to the employees to invite them for the consultation. And it provides specific information that must be shared upfront with the employees before the actual consultations commence.
Okay. What rights do the employees have then in terms of severance pay and other benefits when they're being retrenched?
The Basic Conditions of Employment Act provides the minimum that must be paid in the event of retrenchment actually taking place. So I think one of the key points to understand is that a pension or provident fund are completely separate legal entities. The employer contributes to them, but the employer does not own a pension or provident fund. It is a separate legal entity. So the provisions in both the Labor Relations Act, the Pensions Act, as well as the Basic Conditions of Employment Act would then provide what must be in the kitty in the event of either pension or retrenchment having to be paid out. But in regard of retrenchment itself, there is a minimum that must be paid. It could be, I think, 1 week or 2 weeks the completed year of service.
Okay.
Some employers would have more beneficial ones, but there's a minimum that must be paid.
Okay. Let's take a quick ad break and then we come back with some calls and WhatsApps from some of our listeners who are sharing their experiences. Some of them have got questions for you, Galeboe. So it's 17 minutes after 11 o'clock. After the break, I'm going to go to your calls on 011-883-0702. Have you been retrenched by your company? What process did they follow? Maybe you're an employer and you've got some questions around how to do it in a manner that can be fair, in a manner that can also be up to the law as the legislation requires. You can give us a call or send us a WhatsApp on 072-702-1702. Or maybe you want to share your own experience on how the retrenchment process was handled by your company. We'll start with your calls and WhatsApps after this.
World of Work.
It's 21 minutes after 11 o'clock. We are talking retrenchments on our World of Work feature this morning. And I'm taking your calls on 011-883-0702. Khali, Galeboe Modisapodi, I should say, has been talking to us about the laws, what is expected of employers. He's been talking to us about the kind of benefits that you get as an employee when you're getting retrenched, the severance pay, etc., etc., and also just the processes that are supposed to be followed in a retrenchment process. Is that the process that was followed in your company? I want you to share your experiences with us. If you've got questions as well for Galeboe, you can call us or send us a WhatsApp. Let's start with your WhatsApps.
Good morning, Clement, to your guest there. A quick one, man. So if the company issues a 189 notice and then they invite people to volunteer to what they call VSP, voluntary severance package, if one takes that and the other one decides to allow the process to push them out, is there a difference when it comes to the UIF claim? So the one that volunteered, will he or she be treated as having jumped sort of on their own, or they'll both be treated as having been retrenched the same way? Thanks, and listen on the radio, Kiki.
Okay, thank you. Yeah, Galeboe?
Yes. Remember, the nature of the retrenchment is that it's a no-fault termination. So whether the employees have volunteered once the retrenchment door is opened or not is immaterial to the question of their UIF entitlement. Ordinarily, whether you volunteer or not is also subject to the employer approving the list of volunteers, because one of the issues they consult on is what is the criteria to be used for selecting employees to be retrenched. And skills might be one of them, and how close you are to your retirement age might be the other. So if you volunteer, for example, but you have the set of skills that the employer still needs, you may not be offered a retrenchment package at all. So it depends on how close are you to the defined or ultimately agreed selection criteria for retrenchment, and that may determine whether or not you are granted the retrenchment that you volunteered for.
Yeah.
And once that happens, it has nothing to do with your entitlement to UIF.
Here's another one.
Hi, good morning, Clemmy, and your panelists there, Flores here from the Winelands. How does retrenchment work? Does it work then last in, first out? And then also, when companies, when it seems to be bloated, does it mean that excess people can be put off work? Yeah, I was just curious to find out whether those people can be retrenched. Have a good day, bye-bye.
Thank you. Galeboe?
Last in, first out is one of the key considerations to be determined when deciding on the final selection criteria. It may very well happen, for example, that employees who came in last may have the kind of skills or learning agility that's required going forward. And employees who've been in the company for long may not have the learning agility or even the willingness to learn anymore. So in that instance, last in, first out may not work. But whether it is the agreed final selection criteria will be dependent on the consultation itself and what the reasons for the restructuring that are resulting in retrenchments be. So if the retrenchment are as a result of the organization introducing new technology, as an example, it may happen that the last in, first out does not apply because the employees that joined in last may still have the learning ability to be put through a skills development progress, whereas employees who are longer in service may not even have the willingness to want to study. So it depends on specific circumstances that you're dealing with.
Oh, okay. Here's a question that's also come on the WhatsApp line from Sfiso, who says, Clement, I have a question here. There's a group of employees that were hired 2 months ago. They are still on probation. These employees received letters last week to say they are now retrenched and their last day is on the 31st of October. My question is, why were they hired in the first place? And they left their permanent jobs to come here, and in less than 2 months they must go. Is this fair to them?
Well, it doesn't sound fair at all. One, because there doesn't seem to have been any scope for consultation. It seems they simply received a letter which said retrenched, at least from the facts that are provided. It may very well be that they received a letter inviting consultations. I don't know the content of what they received, but it is possible. But if all they received is one single letter that says you are retrenched, that retrenchment cannot be fair. It doesn't sound fair at all, because there was no consultation, because they may not know what are the reasons for the retrenchment, and those reasons may not be subjected to enough scrutiny for them to pass muster, as they say.
Mm-hmm. Another one says, Clement, on this topic of retrenchments, I'm a qualified chartered accountant and I used to work for a consulting firm. The employer retrenched us, gave notice a day before we had to leave. We were compensated by way of extra 1 month pay as our team was with the organization for a year. This was so sad for me because the employer did not even offer counseling or any support to prepare me for the bad news. Is that, Galeboe, what's expected of employers?
No. As I said, I think the answer is the same as the last one. It doesn't look like in this specific instance there was any scope for consultation. It sounds like it was a foregone conclusion. We're just receiving a letter that says you are retrenched. Here's your retrenchment letter, and you receive X, Y, and Z as the final package. The reasons are not clear. Whether the reasons were justified is not clear. Whether retrenchment could have been avoided is not clear. Whether there's any other way it could be said that retrenchment was not the last resort in this instance.
Yeah.
There were a number of other alternatives as resorts to be opted for as opposed to retrenchment.
Yeah.
It doesn't sound like it on that basis the retrenchment would not be fair.
But in terms of like support and psychological support, should a company provide those services for employees when it's breaking the news that they are getting retrenched? Is that an expectation?
It is a legitimate expectation to have. But also depending on the reasons for the retrenchment, because if the reasons is financial constraints, for example, financial redress of the business, there may not even be money for that. But one of the subjects of consultation is how do you mitigate the adverse impact of retrenchment, and one of them could to help people rewrite their CVs, put their CVs together, take them for a bit of counseling. All of those things will be some measures that can be taken to avoid retrenchment.
Yeah, and then the last one quickly, Dakalo says, Clement, how long does it take for a company to consider retrenchments? I'm with a manufacturing company and it's been applying the short time procedure for precisely 6 months a year concurrently for almost 15 years now.
I'm not sure what is meant by that.
I think I assume, and I'm assuming here, that it could be that the company has been trying to, has spoken to them about getting into this process of retrenchment, but it's been many, many years now that it's been talking about it and nothing has come up. Can a company do that? So do you apply? Do you have to apply to a certain body or institution for you to start the process of retrenchment? Or is it a process that you can start unilaterally as a company?
No, the scenario is not anywhere close to normal because it's not fair to have the retrenchment X hanging on your head for 5, 6, 7 years. It should be something to be dealt with, and it must be over and done with, and then you move forward.
Okay.
What it sounds like a bit is that there is potentially some kind of employment relationship where you're not employed for the whole year, you are employed for 6 months.
I see.
For the other time, you don't have a job. And in that instance, it's not exactly a retrenchment.
Okay.
It's something different. It's a different employment arrangement or employment relationship. So we cannot talk about retrenchment in that regard.
Okay. Can I challenge the company though? If it says we're going to retrench because of 1, 2, 3, can I come back and say and dispute that?
Of course. That's the whole reason why you need to go through the retrenchment consultation. Because the retrenchment decision has to be questioned. It has to be subjected to scrutiny, and then it has to pass muster. And then when it passes muster, then the retrenchment can take place. But if the retrenchment does not pass muster, then it cannot be fair. And once you are terminated, you can then challenge that the retrenchment was unfair, and it may be ruled by the courts as unfair, in which case then either you'll be reinstated or there'll be some compensation that's paid over, which might be in excess of what you would have received under normal.
Yeah, Galeboe Modisapodi, labor law analyst. Thank you so much for making time for us.